Hi, I'm John Mayfield, the real estate tech guy with another Global Real Estate School podcast. Hey, welcome to the podcast. My name is John Mayfield, the real estate tech guy. Actually, our YouTube podcast, I guess we can call them both a podcast or a show. However, either way is fine, isn't it? I think that will work. So thanks for joining. We actually do have a podcast. If you haven't checked that out, be sure and do so. You can go to globalrealestateschoolpodcast.com. It should take you over to iTunes, but we're on Spotify, Podbean, all of the channels. And actually, I want to just quickly, because I want to get into some exam questions you will see on the real estate exam, but very quickly, if you don't mind, the podcast is designed so that you can practice, listen, study, learn while you're in your car, while you're on a walk or exercising. Anytime you want to put the earbuds in and you want to study for the exam, Global Real Estate School Podcast, check that out. The YouTube channel is designed to actually help you pass the real estate exam, and we actually throw up questions like this so that we can prepare and study for the test. So a little more visual, and I'm sure you could listen to these as well if you want to, but let's get right into our first question. Now, I should have probably gone back and looked at our previous videos just to see, have we covered this question? Because I'm thinking it may have been on the last YouTube video that we had gone through, but it never hurts to go through questions more than one time, right? So let's go through this one. You are at a recent sales meeting when one of the agents asked the broker the following question. Hey, for a real estate sales contract to be enforceable, what must be present in all cases? Great question. Let's take a look and see here, okay? So, at a recent sales meeting, one of the agents asked the broker the following question. For a real estate contract to be enforceable, what must be present in all cases? Well, is it an earnest money deposit? I know we covered this question, but it's okay to go over it again. Remember what I told you. It doesn't matter if there's no earnest money, if it's a diamond ring, if it's a cow, if it's even a promissory note, because I think I told you about the folks who were writing contracts in our area years ago, the investors who were buying properties, and they weren't putting any earnest money down. It was just simply a promissory note. Well, on the real estate exam, if you see that question, as long as everyone agrees to the earnest money in writing, diamond ring, boat, car, airplane, promissory note, it's all right. So we can eliminate earnest money contract because you don't have to have an earnest money contract to be enforceable. You could have zero earnest money, and that contract's enforceable if all parties agree to it in writing. So read the questions very carefully. So let's throw A out of the scenario. B says competent parties. Well, let's read on, John. Okay. C says witnesses by a disinterested party. Well, I've never taught in my pre-license course that you always have to have a witness for your sales contract. Notarization does require a witness because that proves notarization is proving the signature is genuine. So you do need a witness for that, but not a sales contract. So we can throw C out. And D says the signature of a spouse of a married seller. Well, great question, because this is how your real estate exam will work. You're always going to be able to throw two out and have two that could be very, very challenging. Now, do you need competent parties? I kind of think you do. Do you always need the signature of a spouse of a married seller? Well, again, the sales contract could be enforceable if a buyer wanted to sign a contract on their own accord. Now, I'm not going to get into deeper conversations on the seller, but when we reread this question, it's just asking, the agent wanted to know, for a real estate contract to be enforceable, doesn't say anything about seller or buyer, just the real estate contract to be enforceable, what must be present in all situations? Well, the correct answer is competent parties. You could have a buyer who enters into a contract and their spouse doesn't sign the sales contract. It's okay. That's not going to jeopardize, that's not required in all situations. But you do need competent parties. So don't forget that, okay? Very, very important. Now, if one of the items were not present, which would invalidate the deed, well, would it be recording the deed? Would that invalidate the deed? Would the delivery of the deed invalidate the deed? How about the signature of the grantee? Would that invalidate the deed? Or the capacity of the grantee? If one of the items were not present, which would invalidate the deed? Well, it's the capacity of the grantee. So we get into these, words about capacity and competent, but if the grantee, that's the person receiving the deed, had no capacity, wasn't able to receive it, then that would invalidate the deed. So those are challenging questions, and would really like to jump over and look at that word capacity a little bit further. And I tell you what we're going to do. I'm going to just jump out real quick, and I'm going to use the old Google mechanism, and I'm just going to say define capacity in a contract situation or in contract law, and in the mean of law. And in the context of contract law, the term capacity denotes a person's ability to satisfy the elements required for someone to enter into binding contracts. For example, capacity rules often require a person to have reached minimum age. Now that is giving us some more information regarding this specific question. Because if the person was not of legal age, capacity, that would invalidate the deed. Okay? So, interesting question. If you see that on the test, just kind of remember that. But that would, if that were not present, the capacity of the grantee, it could invalidate the deed. All right, we'll keep moving on. In this case, Sarah recently listed Bob and Sue's home. Sarah's real estate brokerage firm and her agreement with Bob and Sue is known as what form of agency? Well, remember, real estate listing agreements, agency agreements, are always between the broker and the client. And in this case, it would be between Sarah. She recently listed Bob and Sue's home. The Sarah's listing that she just took would be between her broker and Bob and Sue, and we know that is a special agency. Remember, special for a specific purpose. Mary Davis is presenting an offer to her client Todd Juno. Todd asked Mary, Todd's the client here, Todd asked Mary a few legal questions about the contract. What should Mary do in this situation? Well, Mary, and we study this for the test, you will see this on the exam, and you always need to immediately look for an answer that says, Mary needs to tell Todd to seek legal advice. And so the answer in this case is D, advise Todd to consult legal counsel. Trust me, you will see a question on the exam. I promise you, I double promise you, that will give you a scenario, and the client is asking for legal advice, or the buyer or someone saying, what do we do? And you read that question and you're going to say, you know what? They need to go seek legal counsel or expert advice. So don't let that trip you up, because they'll ask you that question. Jennifer has a listing with Tim. All of the following statements concerning Jennifer's responsibility to Tim under her listing agreement are true, except now all of these choices are true, but one of them is false. We have to get that in our mind as we begin to go through this specific question and the answers. So again, Jennifer has a listing with Tim. All of these answers are true statements, except, well, Jennifer is responsible for any losses to Tim. I don't know if that's true or not. Let's keep reading on. Jennifer must not disclose confidential information about Tim's financial affairs. Well, we know that's true. If Jennifer's Tim's a client of Jennifer, she can't disclose any confidential information. That's her client. Remember, care, obedience, accounting, loyalty, disclosure, all of those, she has to be faithful to her client. So B is true. C, Jennifer must disclose any material facts, even if they have a negative effect on Tom. Well, now a material fact is something that is it's not confidential information, but it could be that Jennifer knows the basement leaks. That's a material defect, but it's also a material fact. So even though if Jennifer knows about it, she has to disclose it to the agent or the buyer or the other party, even though maybe Tim has said, Jennifer, don't tell anybody the basement leaks. Well, C's true. And D says Jennifer should be able to account for any valuables entrusted to her on Tim's behalf. Well, we know that's true. So the correct answer would be A. All of those other choices are true. Jennifer is responsible for any losses to Tim. No, that's not true. So no, we know that answer for sure. Smith Jackson is a property manager for George and Donna. His agency agreement provides him with limited power to bind George and Donna. What type of agency would exist between Smith Jackson and George and Donna? Well, is it a general? I think that might be the answer, but let's read on. Is it special? No, that's a listing agreement, a buyer's agency agreement, seller's agency agreement, specific purpose. But now we're getting into a limited power of attorney. Is it a universal agency? Well, that's when you take care of all of the affairs for the other party. Universal agency, they're almost bedridden. They can't make any decisions on their own. So it's not that. Would it be a dual agency? Well, that's a different type of agency, and that's not what we're getting into in this situation. That's when you work for both the buyer and the seller. You're a dual agent. In this situation, Smith Jackson is just a property manager with a limited authority or power of attorney, and that's an example of a general agency. Okay, general agency. In what corner of a township would you find Section 6? Well, let's think about this. Remember, sections begin in the northeast corner, and a section's 1 mile by 1 mile, and a township 6 miles by 6 miles. There are 36 sections in a township. You're getting lots of possible answers for the real estate exam. So if we started over in the northeast corner up there, right? And we went 1, 2, 3, 4, 5, 6. I'm now in the northwest corner. And remember, a township is 6 miles by 6 miles. And so there are 36 sections in a township. So each of those sections are 1 mile by 1 mile. So now we're over in the northwest corner. So you just draw this out. In what corner would you find section 6? Well, section 1's in the northeast corner, and each section's 1 mile by 1 mile, and there's 36 sections in a township. So we're going to go 1, 2, 3, 4, 5, 6. We're now over in the northwest corner. Okay? Wish I could have drawn that out, but I'm trying to hook my board up into this side of the camera. So let's do one more, and we'll wrap it up for today. Becky has a listing with Anne. Anne mentions over coffee that she's willing to take a lower price than her listed price. Becky's having lunch with a group of realtors and tells the other agents about Anne's home. I see I have Anne spelt with an E one place and without the E in a couple of other places. My daughter's name is Anne, and she has the A-N-N-E, like the Anne of Green Gables, but I'll fix those when we go to the course. But I'm just trying to keep you entertained and having a little fun. And some of those of you who've already pointed that out, you know, I found it too. So anyway, Becky's with these realtors. She tells the other agents about Anne's home and says, hey, bring any offer. My seller will take less than the asking price. Did Becky break her fiduciary duties? I think she may have, don't you? And the correct answer is yes. Anne did not give Becky written permission to share her confidential information. You have to have written permission. She just mentioned it over coffee, and that's not good enough. So be careful and watch those. One more bonus one, since I had Anne spelled incorrectly. I want to leave on a high note, right? Larry is explaining to Julie and Rick some important details about real estate financing. Which statement did Larry make that is incorrect? Which one of these is incorrect? Julie and Rick, since you are the borrowers, you will execute a deed of trust and be the guarantors. B, your mortgage or deed of trust is what creates the collateral for the debt. C, your mortgage is the lien on the property. It does not transfer the title. And D, your promissory note is the security for the deed of trust. Uh-oh, that's a tough question. I wrote that one. I wrote all these. And but this one's really hard. Well, we have to remember that the promissory note is not the security instrument. It only shows evidence of the debt. Okay? The other three choices are all true statements, but the promissory note shows evidence of the debt. It's not the security instrument. Hey, don't click the end button just yet. Please just wait one quick second, because I want you to subscribe to my YouTube channel. But more importantly, all my analytics will go off. I want YouTube to know you like my video, so just let it play. But be sure and subscribe to our YouTube channel. Remember, our podcast is different from our YouTube channel, and you want to subscribe to both of them and listen to both of them, because I go over specific topics on the podcast that are very important for you, and they're designed so that you can listen and go through the test that way. The videos here are totally a different setup where you can watch and listen. But there's one very important thing I want to share with you right now, and that is we now have, that's right, we now have, you see it right there, the Utah Real Estate course approved at Global Real Estate School. It will be live on our site later this week, but you know it's approved. Something else I want to share with you is this brand new program we have called the Ultimate Real Estate Exam Prep. Now, it includes my real estate exam coach. We're actually bundling it with over 500 exam questions, digital flashcards, audio, video. If you've ever taken my real estate exam coach, it's got all these cool videos. But we're including some additional stuff for people all around the country, our review modules that you can watch and study and prepare. So it doesn't matter what state you are in, you need to check out the Ultimate Real Estate Exam Prep. It will be live this week as well, and it's the same low price as my real estate exam coach. So again, it has a lot of stuff. It's the ultimate real estate exam prep, and it's the same exact price as my real estate exam coach, and it works in all 50 states. It's just national content, but it will help you pass the real estate exam on the very first attempt. Well, there you have it. Some of you are going to go down and click the stop button. I'm asking you to just stay with me to the very end to keep those YouTube AI people happy that do all the analytics. Will just blow their mind and boggle them a little bit. But we've got another great video for you to watch, so be sure and check that out as well. Hey, as always, thanks for watching the video. Go out and make it a great day.
Thank you for listening to the podcast for Global Real Estate School. I'm John Mayfield, the Real Estate Tech Guy. Go out and make it a great day.